Hello again. Before the year 2000, English law operated according to a number of principles, some of which were almost 1,000 years old. One of these was autrefois acquit. The very language of this phrase, which is Norman French, shows how far back this particular idea goes. Autrefois acquit is sometimes known, especially in the United States, where it is enshrined in the Fifth Amendment to the Constitution, as double jeopardy. It was a marvellous example of English fair play at work. A man acquitted of a crime, especially murder, was free of hazard for that particular charge forever. The Crown had just one chance to persuade a jury to convict him. Of course, the purpose of this piece of law was to prevent the state from pursuing somebody relentlessly and rearresting an acquitted man and then swearing in a new jury and seeing if they would be more likely to convict than the first one. Sooner or later, by the laws of chance, they would find a jury who would convict the man. This would have been iniquitous and quite unfair. And so from the time that the Normans established courts in this country, following their invasion in 1066, autrefois acquit was viewed as a sacred safeguard against the abuse of the courts by the state. Then came waves of immigration and the first stirrings of the very modern idea of hate crimes and various other matters relating to hostility between ethnic groups. It took a while, though, for this idea to become a popular notion and for crimes relating to race to be put into a separate category from all others. In 1993, a young black man called Stephen Lawrence was stabbed to death in South London. And 3 years later, some of those alleged to have been responsible for the crime were brought to trial and acquitted of murder at the Old Bailey. There, the matter should have rested. There was an enquiry into the case which led to the publication of the Macpherson report. In addition to condemning the Metropolitan Police as institutionally racist, the Macpherson report also recommended that the law on double jeopardy be scrapped. This was done in the 2003 Criminal Justice Act, purely as a result of that racist murder. A man called Gary Dobson, who had been acquitted in 1996, was tried again for the same crime, convicted this time, and sent to prison for life. This was a disgraceful state of affairs. To see 1,000 years of English tradition overturned simply because of one case of this sort, and it was the beginning of the idea that cases involving ethnicity and race should be elevated to a separate category from all other crimes, that there was something particularly unwholesome or to be deplored about if a crime had an element relating to racism. It wasn't only the idea of double jeopardy which was done away with as a direct result of immigration and our modern sensitivities about racism. Freedom of speech has largely gone the same way. For centuries it was accepted that, with the exception of language liable to cause a breach of the peace or intended to incite violence or treason, people should be free to say pretty much what they pleased in public. There was no concept of hate speech or any of the other restrictions which have now been imposed upon what we say. If somebody wished to use unpleasant language to describe black people or any foreigners or other ethnicities, there was no legal restriction at all on doing so. Social disapproval acted to discourage a lot of this kind of thing, of course, but if someone wished to express the view that they didn't like foreigners or that they disliked black people, people were perfectly free to do so. Today, one can be arrested for expressing such views. This is the case even if there's no likelihood of a breach of the peace and nobody listening to you minds what you're saying. I don't personally agree with the use of offensive words relating to ethnicity, nationality, or race, or anything of that sort. But I believe people should be free to express such views and others should be able to contradict them if they wish. These are just two examples of the way in which racism and the fear of racism has altered our laws needlessly. We had a perfectly good legal system, one which grew over the centuries and was suited to the needs of this country. Because of immigration and the perceived need to avoid immigrants being offended, our laws were changed. This was a bad and unnecessary thing.